There we go. Hi, everybody. It's Angelina here with the Deals with Angie team. As you know, we do our Tuesday tune-ins every Tuesday. And I am so excited because we have our Senator and Attorney Tameika Devine on, guys. Um, just want to kind of give you, hey, she has taken time out of her busy schedule to get on with us today, and she's going to be sharing some great info. For those of you all who don't know, uh, oh my goodness, I'm just going to say Senator Tameika Devine because I'm old school and respectful. She has been an attorney. Oh gosh, I've known her. We've known each other actually since I was working at a law firm, Rogers, Townsend and Thomas. For those who all know, I have a background in dealing with loss mitigation and foreclosures, which is why I do this now. I've known her since then because she was really good friends with my attorney there. And then also our children went to school together. And so we've known each other for a while, even before getting into the real estate field, because we've just been around family wise. Tameika is the co-founder, of the Jabber Isaac law firm here in Columbia, South Carolina. It was one of the first all-woman African-American law firms here in the state. She practices, the area of practices for law is for real estate, probate, and personal injury. And she also served guys on our Columbia City Council for a while, since 2002. And from there, she is now our senator. So, Ms. Tameika, thank you so much for coming on.
Thank you so much for having me. It's a pleasure to be here. And always, I love educating people and talking about real estate and probate, two of my favorite issues.
Yes, I just want to show you what we just have. Look what we have. Somebody's like, I love her. There you go, Tameika. You already got a fan. I'm telling you, I had a lot of people. I wasn't able to push, you know how it is with broadcasting and advertising things. I'm telling you, I'm seeing people, they reaching out to me by phone, by online. They're like, Angelina, I'm telling this person to get on. I'm telling that person. Anybody that knows you knows that you're the expert when it comes to these things. And guys, I really wanted to reach out to Tameika to get on tonight to talk about estate planning, because we have dealt with these deals and these type of files for years now. And I felt that it was important for you all to not, we're not trying to just make sure that you purchase the real estate, but we want to make sure that should anything happen, guys, you're protected and your family's protected. And it's important to have the guidance of someone like Tameika when it comes to these things. Everybody wants to get into investments and acquiring assets, which is wonderful. But at the same time, you got to make sure that you have the proper procedures in place too, should anything happen, for your family, for yourself, for your children, for your businesses. All right. So, first of all, Tameika, if you don't mind, if you want to share a little bit more about yourself while we get started so people can see.
Yeah, no, absolutely. Good evening, everybody. Happy Tuesday. I'm glad to be here. I have been in practice since 2001. So our firm this year will reach 23 years. And all of the 23 years I've done real estate. I actually got into doing real estate because my dad was a realtor. And when I first went out on my own, he was like, I need a real estate attorney. So you're going to do real estate. So I honestly really didn't have a choice. So we started real estate. But over the course of being in practice over the first year or two, I saw so many real estate deals that had issues with probate. Either estates weren't probated, deeds were done incorrectly during probate, there were heirs, there was just all kinds of mess. And instead of sending those files away to fix them and then come back to close them, I decided I needed to get into probate so that I could do both. And so I've been doing real estate for about 23 years. I've been doing probate for about 21 years, and I really enjoy it. I think that real estate and probate, people don't realize how interconnected these two areas of law are. And most people don't think about the fact that, you making a decision to or really not even having the right information and saying, hey, I need to probate this estate, or, I know I need to probate the estate, but the court says I don't need a lawyer, so I'm not going to get a lawyer. And the court will tell you, we're not lawyers. We cannot give you legal advice. We're just going to let you do whatever. And somebody may do something, and then at the end of the day, you find out that something's messed up. And sometimes it's not too late, but sometimes it's more complicated to fix it because someone has passed away, or, you filed something incorrectly and you've got to go back and fix it. So that's kind of why I got into doing what I do. And I love helping people with estate planning, because it really goes into building wealth within our communities and leaving a legacy for your children. You've worked really, really hard for what you have. You don't want to get it messed up or getting taken away or lost because you failed to plan correctly.
Awesome. And and those are things that people don't think of. They always think too, oh, well, am I old enough to even have this? I don't need that right now. We think as soon as we think about when we talk about wills and things of that nature, we just automatically assume that we need to be older or in our latter years to be able to do those things. And I used to, prior to real estate too, I also used to deal with insurance. And so I've seen kind of, if you don't have certain things in place, how it can affect even when it comes to that, when you're talking about wills and the probates and the trusts. And so since we kind of started with the probates first, do you mind kind of elaborating on what probate really is? Or should we kind of start talking about wills and trusts, since they kind of interconnect with each other?
Well, I can just start with probate, because I think that's one of the key things is people don't understand that the word probate means is how stuff passes upon your death. So probate is the process. Probate court is the court which helps facilitate that process. But I get people all the time say, oh, I want to avoid probate. And I do help people avoid probate, meaning probate court. But probate, all that really means is the way things pass upon your death. And so the biggest thing, going to your point about wills, trust, and all that kind of stuff, is you really need to make sure that you sit down with an experienced professional, myself or someone like me, to do your estate planning, because a probate solution and an estate plan for your neighbor or your cousin or even your spouse may look differently for you because of what you have, what your goals are, everything else. And so I would strongly encourage anybody to do an estate planning process, because through that process, we will talk about, what you can do that avoids probate. If things have to go through probate, making sure you have the right mechanism set up to make it easier and cost less money. And then ultimately making sure that at the end of the day, when you're not here, the things that you have worked really, really hard for get preserved, either passes to who you need them to go to, or they can be sold, and then that wealth go to the people that you want it to go to.
And with the estate planning, what are some of the things you need to have to be prepared to when they set up their consultation with you that you would need to know? And what are some of the crucial things that you feel that they need to put in that estate planning?
Well, excellent question. So when people call me and say, like, some people will call and say, hey, I need a will, and we'll set them up an appointment, but we're like, we're going to set you up an estate plan appointment, because consultation, because you definitely need a will, but you may need some other things as well. And so when people call for a consultation, an estate planning consultation, one of the things that we do is we send a general consultation questionnaire. It kind of gives us an idea of what are your current assets. What does your family look like? Do you have, are you married and have children? Are you divorced? Are you separated and not divorced? Which, is another consideration. Are you, do you have children? Are you part of a blended family? So those are things that we need to know. And then again, what are your assets? And then how do you own those assets? Do you co-own them with other people? Do you own it yourself? And so typically we'll ask those questions. And then I'll also ask that bring with you what you have, if you have it. So copies of your deeds, copies of titles to vehicles, your insurance policies, your annuities, other things like that, just so that we can have a full understanding as to what your assets are and how they're currently held, and then how you want them to pass, so that we know what you need to do. Because one of the things, like I said, people a lot of times will say, oh, I want to avoid probate. And what they really mean is they don't want their things to have to go through probate court, because they don't want their heirs to have to go through that process. And if that is one of your goals, there are ways that we can do that. It may be by setting up a trust so that things don't go through probate court. It may be retitling your deeds in your car and your bank accounts so that stuff doesn't go through probate court. So it just kind of depends on what you have and what your ultimate goals are. And all of that is what we will discuss in a estate plan consultation.
Okay. And can you kind of, since you kind of also touched on trust, can you kind of just touch on a little bit of what wills and trusts do and how that's kind of like how that also plays? We kind of touched on a little bit when it deals with the estate planning, but just a little bit furthermore.
Yeah, no, absolutely. I'm so happy you asked that question because I'm gonna tell you, in the last maybe year and a half, I've had so many people call and say, I want to trust. I want to set up a trust. And what one of the questions I first asked in that consultation is, well, why do you want to trust? Why do you feel like you need to trust? And I'll tell you that a lot of times there was like this whole thing. I don't know if it's still going on because I'm not really on TikTok, but like there's this TikTok thing telling everybody, this is how you protect your assets and you got to put everything in a trust and blah, blah, blah. And that is true sometimes. But again, it depends on what you have. I don't mean this lightly at all. Bless his heart. He's actually a child of a friend of mine, but this young man called and he was like, Miss Tameika, I want to set up a trust and, whatever. And so when I kind of gave him stuff, I was like, well, what are your assets? And he didn't have any. He was like, well, I want to be like the Rockefellers, I'm going to build a business and then I want to set up a trust. And I'm like, okay, come back to me when you become the Rockefeller, because right now you don't have a trust. I mean, you don't have assets. And yes, you can come to me and pay me to set up a trust, but most people don't understand. Like setting up a trust is one thing, and that's the actual physical work of establishing the trust. And think of a trust like its own independent entity. And once you set up a trust, then you have to do what we call fund the trust. So you then have to move your assets into the trust in order for them to be protected. And one thing people don't realize is if you have your house, which is probably your biggest asset, but you have a mortgage on that house, you actually cannot put that mortgage and put that house into the trust unless your mortgage company says it's okay. And so I have people be like, oh, I got to ask my mortgage company. And I'm like, yeah, you do. Because mortgage companies, if they have to foreclose, it's going to be difficult, on the trust. Or if you refinance, if rates go down, most mortgage companies are not going to lend to the trust because the trust is an independent entity. They're going to want to lend to you personally. And if you have the house in the trust, then they're not going to be able to do that. And so you've got to get permission from the mortgage company. If you have annuities and bank accounts and you want them to go into the trust, you probably currently have beneficiaries listed. You're going to have to change those beneficiaries to the trust once the trust is set up. So I tell people that all the time, like it depends on what your goals are and what you're trying to do, and whether or not it makes sense. If you have a house and a car and some money in bank accounts, you can avoid probate court without putting stuff in the trust. But the question is it really cost effective to set up a trust, move these assets into a trust, when ultimately, when maybe you're not here, all those assets are going to be sold anyway. And so I think the thought that people have on what a trust does and what it doesn't sometimes is not really accurate. And so what we do is we will talk about that. If I have people who tell me they want to set up a trust, I first ask them why, and then I figure out kind of what their assets are and whether or not it really makes sense for them to have a trust. For real estate professionals, real estate investors, if you have several pieces of property, it may be beneficial to set up a trust, but it may not. You may want to just set up separate LLCs for your real estate. And so we talk about that as well, because if you put everything into the trust, and then you've got, 10 pieces of property and they're all rental, and someone gets hurt on one rental, and all the properties are in the trust, again, the trust could potentially not safeguard the other 9 pieces of property. But if you had 10 LLCs versus that one trust with 10 pieces of property, it might make more sense. So again, those are things that we dig deeper when we do a consultation and really figure out what's best for you.
I'm glad you brought that up, because that was going to be my other question, because we do get asked that from investors a lot. Should I get all of them in a trust? And that's why we say, hey, you need to talk to an attorney, because exactly what you just stated right there in regards to protecting those assets. Now, what we also talked about with the heirs, can you talk about once they have these things set up and they do the consultation with you, how it works as far as with distributing those assets, that real estate, to their heirs? How does that work?
Mm-hmm. So it depends. And I will say this, I know we talked a lot about kind of the estate plan. Part of the estate plan typically will involve having a will, having a durable power of attorney, which helps with financial issues, and then having a healthcare power of attorney. So those typically are the 3 documents that we have in our estate plan. And then if you choose to have a trust, then a trust is in there as well. But that's typically kind of the estate plan. The will is critical. You want to have, and I get people all the time is like, "Ooh, I can go, go to LegalZoom and download a will, or I can go to Office Depot and get a form or whatever." And does that work? And yeah, it could. But I tell people all the time is you don't realize that your will is not sufficient until you're no longer here and your heirs realize it's not sufficient when they take it to probate court. And again, I told you that's kind of how I got into probate court, because I saw so many things when things weren't done correctly. And so I know I've got lots of folks who, they'll say, well, I have everything in my wills going to all 5 children. Well, to your point and to your question, if your will says that all 5 children inherit that one house, your kids are 30 in their 30s, some of them are married, they have kids, and now all 5 kids ain't gonna live in that house. And even if they decide, okay, we're gonna rent it out and that's gonna be income or whatever, somebody's got to be in charge of paying the taxes, paying the maintenance, making sure everything is done. And sometimes it's just really difficult. And so part of the estate planning process is also digging deep and talking realistically about what you want to do with what you have. And so when it comes to distributing assets, again, when things go through probate court, the probate court oversees that process. So if Big Mama has a house and she leaves it to the 5 kids or says, I want to sell it and let the 5 kids split the proceeds, the probate court is going to oversee that and make sure that happens and make sure that happens correctly. How a house passes to its heirs is through the probate process and through probate court and through a deed of distribution. You will hear a lot of people say, well, it's heirs property. There are a lot of people, and I will tell you, I hope if y'all don't hear and remember anything I say tonight, please remember this, is that if someone you love passes away and they own property, whether you all agree, so-and-so is going to take care of the mortgage or so-and-so is going to take care of the taxes or whatever, you have got to go to probate court and make sure that house passes. Because if you don't probate someone's estate within 10 years of their death, if you don't do it within 10 years of their death, then you lose the ability to probate a probate in South Carolina, and then you have to go through another process to transfer that property. And again, I have so many issues. I got a piece of property right now. The title search just came in today. Client was a gung-ho. She's one of my investor clients, actually, and was talking to this guy, and he wanted to sell this piece of family land, and he's been paying the taxes. He's been doing everything. So in his mind, I guess he thought he owned it. He did a contract with her to buy this piece of property, and we got the title search back today. There's like 8 people on this title. And so I have not had a chance to call her yet, but I'm going to call her and explain to her, now we need to sit down with him and find out who all these people are. And he needs to understand that I don't know if all these people are still living, and if they are, then that makes it easier. Then all 8 of them need to just sign the deed over to her. But if they're not, which probably tells me they're not, if he's been paying the taxes and everything else, then there probably are some issues of estates that need to be probated. And then if there are some who have passed away more than 10 years, you're not going to need to probate their estates. You're going to have to do a petition to determine heirs. And it's going to be a lot more complicated, a lot more expensive, because they didn't do what they needed to do when the first person passed away.
And then at the end, you got to make sure all 8 want to sell the house.
Right. Yeah. And make sure it's worth it, because if one guy has been paying the taxes for however many long, he's going to want reimbursement for what he paid. But everybody's going to want the money. It becomes an issue. So again, that's all part of what happens in probate as well. It's like we will talk about that through our estate planning consultations. And I strongly encourage, like when I have people who are leaving a house to multiple heirs, I always tell them, please think about it. And ultimately it's your decision, but think about what may happen when you're not here. When mama's not here to be the common voice and make the kids play nice. When daddy's not here to say, this is what I want. What may happen? And I will tell you that some of the best of families I have seen have fallen out once mom or dad or some sister has passed away, and now there's something there for people to fight over. Sometimes money, sometimes something sentimental. But when people grieve in different ways and they handle that grief in different ways, and ultimately I've seen some of the closest family members that people thought would never have issues during a probate process.
And you're right, because some of the files that I've worked on, it would be families and they're in disagreement on what to do to the properties. And sometimes I would just sit with one and be like, well, why is it that you just won't do this and they do that? And they're like, you know what? We do need to do that. And they take the emotion and you say the sentimental value out of it and just look at it as hey, let's look at this, not to disrespect, but look, it's still a business transaction. What's going to make sense to where it's fair for everybody versus that was left to me and Big Mama left me this and she told me she wanted me to have it. Okay, but like you said, there's still things that are attached to that home. You have the taxes. I've had people who have called me and they're about to lose Big Mama's house because of the fact they have not paid the taxes. You have one heir staying in the property who's not paying any rent, anything. And then everybody's like, oh my goodness, we need to be able to get in and pay these taxes. And the thing is, with the values of these properties going up, these counties are realizing that Big Mama's house is worth some money. And so they're shooting those tax fines up to be able to win those properties. And we're going to come in and trying to see what we can be able to do and make sure that for one, that it's able to be sold, which is why we have to sometimes give you a call.
No, excellent point. Two points you just made that I want to point out. So I have a case right now. Mama passed away. Sister was living in the house. Sister passed away. She was paying the taxes, doing whatever. She's passed away, and now it's up to the rest of the siblings. And so it's been a year or so. And of course, last year was also kind of a reassessment year or whatever. So anyway, the county found out, the county knows because it was not in the state that it's not owner occupied anymore. The taxes went up to the 6%. And the family called me. They were like, well, why did the taxes go up? And I tried to explain to them, well, the probate process has taken over a year, and now the county recognizes this is no longer owner occupied because the owner passed away. So it is y'all's best interest to go ahead and decide what y'all are going to do. If one heir is going to have the house, if y'all are going to sell it, do whatever, but y'all need to decide that quickly because it's now almost July. So taxes are going to be due again very shortly. And it was culture shock for them to know that they had to pay their taxes. And I will tell you, so many times I will have one or two heirs that will get their money together and pay the taxes. And some people be like, well, I don't want to pay the taxes. I don't have the money, but you got to do that. The second point that you brought up is the other thing that people also need to realize is if whoever passes away still has a mortgage on that property, the mortgage still needs to be paid. Whether that house is in probate, whether it is, 5 people are inheriting it, whatever, that mortgage still needs to be paid. The mortgage company does not care. And you know this from your loss mitigation work. The mortgage company doesn't care if it's in probate, if it's out of probate, who the heirs are, whatever. They want their mortgage paid. And the mortgage company can initiate a foreclosure on an estate. They just have to name the heirs. But I get so many people who, for some reason, think, well, it's not legally in my name yet, so I don't have to respond. Yes, you do. And that house can be taken, like you mentioned, for taxes. It can also be taken foreclosed on for failure to pay taxes. And you don't want that to happen. And so those are all things that need to happen sooner rather than later when someone passes away. But in order to really alleviate all of that, every single person needs to have a will. And we didn't really talk about the intestate process, but just so you know, if you pass away in South Carolina without a will, then the law states who inherits. And it goes to half goes to your spouse, half goes to your children. If you don't have a will, if you don't have a spouse, they all go to your children. If you're not married, no children, it goes to your parents. If you don't have a parent, then if your parents are no longer living, then it goes to your siblings. Either way, I'm gonna tell you, it becomes a process. I have seen so many issues where, someone passed away without a will, and an estranged spouse inherits half, and they're not together, but they didn't get a divorce, so legally that's still the spouse. So legally they get half. I've had issues where there has been a absentee parent who has never taken care of the child, never paid child support or anything. But because the child passed away with no spouse and no children, and it went to their parents who never were married, dad was never in the child's life, inherits half of what that person had. I mean, so I've seen the horror stories. And so I'm just telling you, if you are listening to this right now and you do not have a will, that should be the first thing you do. July 1st is around the corner. I tell people all the time, you make your monthly and your quarterly goals. We're about to get in third quarter of 2024. Do not let third quarter of 2024 hit without you having a will. It will save so much heartache, save so much money, and it be just really a blessing to your heirs.
And I'm glad you said that, because I had a situation, and guys, just to let you all know, just because you're married does not mean that your home is going to go to your spouse. The full interest of the property. I've had situations where there wasn't a will, and the spouse died, passed away, unfortunately, and half of it goes to the spouse, and the other half, if you have minor children, went to the minor children. But guess what? They're minors, so guess what they do? And you can correct me if I don't have the proper language, but they appointed a guardian ad litem, and it cannot be the spouse. So just to break it down for you all, mom and father, mom passes, dad gets his half. You would think that dad would also be in charge of the kids' half. No, they put mom's mom, the grandmother, over the kids' half. And that's come, and how that proposes the issue. I'll tell you, like, we had one, the dad wanted to sell, but guess what? The mother of the wife that passed, she didn't want to sell the house. She felt that it was a sentimental value of her daughter. They worked hard for that house. He's looking at it like, I'm trying to get my kids out of this home. This is bringing to me memories. I want to start off fresh. And guess what? He couldn't do anything with that home unless the grandmother signed off of it, because she was appointed by the courts to handle the children's interests.
Mm-hmm.
Yeah.
And I'll tell you, you're absolutely right. And the funny part about it, so to that point is, in that situation, the court can ultimately make the decision. So if he can make the case as to it is in the best interest of the children, even if grandmama wants to fight it, ultimately the judge can decide. But guess what? You're going to pay money in the probate court to have that fight, and grandmama, yes, you're right, still has that ability. But the other thing is, and I tell people this all the time, they don't realize, then say you sell the house, those children, whether it's they own half, they own a quarter, whatever they own, that money has to be set in a protected account for those children until they become of age. And so you might be dad and you might be paying the mortgage and everything else, but once you split the proceeds, then you got to set aside whatever portion those children get and go in account to pay for their college or whatever else. And the court has to then oversee that, especially if they're going to inherit more than $10,000 from that. The court has to oversee, and you've got to give an annual report on what's happening to the children's money. So if you invest it and you're making money off of it, or you're losing money off of the investment, you got to report to the court what's happened to these children's money over the year. And so that's what costs a lot more money. And so that's why I tell people, again, you need to have a will. If you have children, then there is no way that you should be in a situation that you haven't planned properly for those children. And those children inheriting pieces of property is a nightmare. And a lot of that money that could be used to protect the children gets spent on legal fees and court costs because you have to go through that process.
And nowadays, with so many people, they may not, because we have people all the time that purchase property, whether they're married or not. We have two sisters may purchase property, two brothers. We may have long-time relationships. They've been a long-time relationship. They purchase properties. When you have things also with blended families, two families who are now married and they're two blended families, especially when you have either young families or sometimes you have grandmother found love again. And now she's, buying her property. Are there anything that you could be able to say that's different when you're talking about and speaking about blended families when it comes to estate planning, probate, things of that nature?
Yeah, no, absolutely. I mean, I think that's something that has to be a real conversation when it comes to blended families, because, nobody wants to think about what happens when they're not here. But think about it, you love that person. And the whole family might be getting along great. But again, when you're not here and you're the glue that's kept the family together, or at least kept everybody cordial, when you're not here, it could be a mess. And so, I've had situations where I actually had oh gosh, a probate case that lasted 4 years. And when I say years, it lasted for years. Husband and wife, they both found love later. So they got married. They both had children from previous relationships. Husband and wife passed away within days of each other. They were in a car accident, passed away within days of each other. Husband had kids, wife had kids. There were properties, one property had sentimental value. This was the house I grew up in, that my dad had. So this should be mine. But again, no wills. The house goes to the spouse. So even if this was a house that, your daddy who passed away bought with your mom, and then your mom, you know, died, and that but she was remarried, that house, half of that property goes to that stepfather, and then he passes away, his children get a portion of that house. And you're in your mind thinking that ain't right, that's my daddy's house, and blah blah blah. And yeah, that's what you may feel, but that's not what the law says. And that could have all been taken care of in the law had there been a proper planning. And so in estate planning, I think that's what you need to think about as well. And sometimes I have a lot of couples who will come to me to do wills together. But I always kind of talk to them separately and say, hey, let me know. There's some decisions y'all may need to make independently, understanding what may happen when you're not here. And sometimes people just want to keep everything friendly and happy, and everybody just thinks it's all going to work out. Y'all aren't going to be here. You're not going to know that your kids are fighting over this house. And so ultimately you need to have those conversations. So are there assets that you brought into the marriage that you want to make sure stay in your family? And so you want to make sure that your will notes that. If there are assets that you all did together, and that it may go to whomever, figure out who's more responsible to take care of that. So there are some special considerations I think that blended families need to have, but again, a lot of that can be taken care of with a proper estate plan, and ultimately making sure that you have a will so that things go to who you want them to go to, and not who the law would dictate go to because you pass away without a will.
Exactly. I had someone that did put a question up on the chat. This was the question: is probate required if there is a trust?
Great question. It is not. So again, a lot of times I get clients who want a trust because they don't want things to go through probate. And so that is always our goal. If things are in the trust, and remember I said you have to set up the trust and then you have to fund the trust. So you have to put the things that you want in the trust, you have to put them in the trust, meaning you have to do deeds to the property, titles to the titles to your bank accounts, that kind of stuff. But if things are in the trust, they do not go through probate because they stay within the name of the trust. So even once you're not here, it stays in the Tameika Isaac Devine Trust. And so it would stay there. But we also, part of the estate, remember I said the estate plan, and you leave, there's the 3 documents I always say you have to have: the will, the power of attorney, and the healthcare power of attorney. And then you may have a trust as well. Even if we do a trust, we're still going to do a will for you, because sometimes there's property, either after acquired property that you failed to put into the trust, or maybe property that you inherit that you didn't realize that you had an interest in. You have a sister who passed away, didn't have children, didn't have a spouse, your parents are no longer here. So you, as that person's sibling, inherits part of their property, and you weren't even thinking about that when you did your probate plan or estate plan. And so that property is not in the trust. It comes to you individually. You need to make sure your will says who you want things to get. And so a will, sometimes there's just a very generic will that says any and everything else that's not my trust, I want to go to my spouse, or I want to go to my children. And so for those reasons, you may have to go through probate just to take care of any other things that are not in the trust.
Awesome. And oh my goodness, okay, we're getting questions. Hold on. have another question. Can you get your assets while you are still alive?
Can you get your assets while you're still alive? I'm not sure if they're
So
your,
you're
I guess if they're your assets, yes. I mean, I guess if the question is like, are they still your assets if you put them in the trust? Yes, because most time you're going to make yourself the trustee and the beneficiary. So they're still your assets. They're just in the trust. And it just depends on how you have the trust. Now, if you do an irrevocable trust, which some of my clients have lots of assets, sometimes their tax attorney tells them they need an irrevocable trust or something. Those things, they are still your assets, but you lose a little bit of control over those assets if they're in an irrevocable trust. But if you set up a living trust, a regular revocable trust, which 98% of my clients do, then yeah, you still own those assets. They're just no longer in your name personally.
okay. And since we're also talking about as far as with our heirs and executing responsibilities when it comes to real estate or when it comes to the estate planning and things as such, what are the responsibilities for that personal representative, what that means, and so forth? Because a lot of times people think because they're the oldest child that means they have control, and we would see this a lot even when I dealt with real insurance, that the oldest sibling automatically assumed that, oh, I'm the oldest heir, the oldest child, so therefore I'm the one that's supposed to be the representative. And sometimes that's not the case all the way.
Yeah, sometimes it's not. Yeah, no. So in South Carolina, we call them the personal representative. What you probably hear on TV and in other states, executor. So you hear people say executor, you hear people say personal representative. It's basically the same thing. It's the person who administers your estate. And that person does not have to be a family member. It doesn't even have to be somebody who inherits from the will. And so what I always tell people when we're doing our estate planning is when you're thinking about who's going to be your personal representative, pick someone you can trust, someone who is a good business person, who's a good bookkeeper, because they're going to have a lot of responsibilities as far as accounting to the heirs and to the court, who where the assets are, what the value of them is, what you're doing, what you're paying, how you're paying it. All that has to come into play. And I'm gonna tell you, I mean, you can have, I mean, we all know that. I mean, you have your kids, you know your strengths of your kids, and you know the weaknesses of your kids. I mean, you love them all, but you know if your daughter can't balance her own checkbook and got bills out the wazoo, you may not want to make her your personal representative. And I will tell you to the really stress this, Angelina. You asked the perfect question about what are the responsibilities. The personal representative's responsibilities is to be the fiduciary over the estate. They have to make sure everything is paid, and they have to make sure that everything is accounted for, so that any heir says, I want to know where every single penny went, that person can pull up their spreadsheet and write down and say what they paid, how they paid it, where that money came from, and everything. I will tell you, I have had, particularly here in Richland County, I've had the probate court put personal representatives who may be children in jail because they have mismanaged funds. Most time it's intentionally. Now, if they just made a mistake here or there, they still have an issue. I mean, they still have a responsibility to the other heirs if they made a mistake and it was an honest mistake. But if they've mismanaged money, like they have taken money out of the estate, and I've had people do that. They've taken money out of the bank accounts and they've gone on trips and they've paid their mortgage and they've done that kind of stuff. If you do any of that, that is breaking your fiduciary duty, is criminal, and the probate court can put you in jail. The other thing is the probate court.
I'm sorry. Do you mind repeating that just one more time?
Yeah. Yeah. Now I've had a couple. I had one, bless her heart. She spent Christmas a few years ago in jail because the probate court was not playing, and they felt like she took money and did not spend it the way she was supposed to, and the judge put her in jail. And she spent Christmas down to Alvin Escalade. So it is real. It is real because the probate court does not take it lightly. When you sign on to be a personal representative, you have to sign what's called a personal representative affidavit, and you take an oath that you are going to take your responsibility seriously, and you are going to do what you're supposed to. And that means you cannot use estate assets for your own personal gain. You cannot, and you can now. Personal representatives can take a fee at the end of the estate for the work of doing a personal representative, and state allows that, but that's at the end, and that has to be approved by the court. But if mama has an account with $50,000 in it, you can use that $50,000 to pay the mortgage on the house, the taxes on the house, legitimate estate expenses. But you cannot use that $50,000 to go on vacation, to pay your mortgage, to pay your car payment. That is not proper. And so it is. I stress that to my personal representatives. The other thing is, what if any of the heirs feel like the personal representative is not the best with money and might not be trustworthy, they can require that the personal representative be bonded, which means you go to the insurance company and get a bond. So, and it will insure you for any losses of assets. So the situation I talked about, like if that woman had been bonded, if the heirs have required that she be bonded, and then she used that money, the insurance company would have paid back the estate for the money that person mismanaged. But most estates don't require a bond, because most heirs say, "Oh, I'm good. They don't have to have bond." But you can, as an heir, request that the personal representative be bonded if you have any concern that the assets are going to be protected.
I never heard of that. That's great information, and that's something that all the heirs have to kind of agree to do that. And I'm assuming it's paid out of the estate for the insurance bond.
Yeah, if it depends. The court has to say it. I mean, if it's because the person is not trustworthy, but they're the only person who can do it, then the court might say they have to pay it themselves. But again, that's if there's no will. If there's a will, typically in the will, when we name a personal representative, we will say, and the person served without bond. So if the will nominates that person and says they'll serve without bond, even if the heirs say we feel like they need to be bonded, they're going to go with what the will says. So again, I mean, the moral to the story really is a will answers most of these questions. A lot of the scenarios I'm talking about is when there isn't a will, you have these other things that might come up.
Have to worry about it. And yes, we have actually two questions. One of them I think is kind of gearing more towards insurance, but I'm going to ask both of them because I tell everybody to put their questions in chats. One of them is, and I already know what the answer is going to be to this one. How do you feel if someone gets the will notarized? So do you suggest that they go through a lawyer? You actually take care of all of that, correct?
Yeah.
Right.
So yes, when we do a will, we will, we'll go over it with you. We'll make sure it's what your wishes really are, and then we'll make sure it's a witness and notarized. I will tell you, it does not have to be notarized. So under South Carolina law, the requirements for a will is the will has to be in writing. It has to state what your wishes are, and then it has to be witnessed by two people who do not inherit from the will. That is a big thing, because I'll tell you, I just had a will challenge that one of the witnesses was one of the people who inherited from the will. And so it invalidated the will because she was taken from the will. You can't, that can't be done. And this was something that this man was this man was on his deathbed. They went to some place and downloaded a form, had a notary come to the house and had him sign, and the daughter was one of the witnesses, and then the notary, and then the man died, and then they presented this will, and we were in court on that, and that will was invalidated because she was a witness to the will that was leaving her stuff. So you can't do that. So again, it's just best. I mean, you're honestly not going to pay but a couple $100s for a will. If you have a will and that will is challenged, and then ultimately it doesn't do what you say, your heirs are going to pay a couple $1,000s. It just makes better sense for you to go to a professional and get a will done.
Okay, they're saying thank you, so we answered it, and that was going to be one. That was one of the questions that was asked for me earlier to talk about kind of what the costs are. I kind of told them it depends, because we, that's so important about them doing the consultation with you is finding out all the things, because they may have 5 properties, they may have 1 property, they may have no property, and that way you can be able to guide them on what they need to do. But like you said, guys, like she stated, everybody needs to get a will. Everybody. And I know I've been putting up everybody's comments, but what I'm going to do, guys, is I'm going to put up her information right here for you to get started and to reach out to Miss Tameika in regards to this. We do have this one question. I just wanted, it sounds like it might be more insurance, but the question was, should you take out life insurance to cover the expense of your mortgage and taxes after you pass?
That is a great question. And actually, I've actually started with some of my wills, even telling people about final expense policies as well. So yes, insurance is a good way to defray a lot of the costs so that your heirs aren't having to come out their pocket. Because like I mentioned, if there's a mortgage on the property, somebody's going to have to continue to pay that mortgage until the probate process is done, unless you've done something else to take care of it. And so if someone has their own mortgage, most time they can't pay their mortgage and yours as well. And so, yeah, if you have insurance, and you say, well, I have this insurance policy, and I'll tell you, my mom is like this. My mom is a stickler, and she used to be an insurance person, so she's got tons of insurance, and she has written down. She's told me, okay, with this policy, I want you to do this, and with this policy, I want you to do this. And so, although I'm the beneficiary, and so legally that is a non-probate asset, she's told me what to do with that money. And so again, if you've got somebody listed as a beneficiary in your insurance policy, that money becomes theirs. It goes directly to them from the insurance company. But if you want that to be used, you need to tell the beneficiary, but we can do that, and we can note that in the will, so that the probate court will ask what happened to this insurance company. And the will says this insurance company where Tameika was the beneficiary is supposed to go and pay off Veronica's mortgage. And so those are some things that you need to do. But I definitely would also encourage people to do a final expense policy. Those things are relatively inexpensive. And I'm gonna tell you, y'all see it like I do. I mean, you see on Facebook, people have GoFundMe accounts and everything to bury somebody. That is not a wealth. That's not a wealth strategy. And I mean, it's just, you need to plan, and none of us are guaranteed tomorrow, and anything can happen. And so a final expense policy may cost you $5-10 a day or $10 a month or something. They're fairly inexpensive, but it will pay those last expenses. And so, like, even if somebody has an insurance policy, a lot of funeral homes will take an assignment of the insurance policy, but even insurance policies don't pay that quickly. But a final expense policy will pay like right away, and they'll pay for the burial, the tombstone, the church, all that stuff you need to do. Even I've had heirs who they paid plane tickets to fly son or grandson who's in the military overseas and can't get back. They've paid for plane tickets. So final expense policies are really smart as well.
They are. And just to kind of pull out back in deep in my insurance brain, term policies too, when you're talking about mortgages, because those are very inexpensive and good to have. And you can have a term policy. It used to be now, guys, I like to always do my disclaimers. You want to talk to your insurance agent, and if you need one, Ms. Tameika says she has someone that she knows, and also we could put you in touch with some people too. But even with term policies, you could be able to have those at least to 72. Final expense, there's no age limit on those, but term policies, it used to be 72 unless they've changed that, but it's something inexpensive to have. And so we added 2 things to your list. 1 is a will, and 2 is some insurance, everybody. Okay.
Yeah. And I'm gonna say 3. This is one thing 2 things we didn't talk about. And I know we're running short on time. And so I'd love to come on again anytime.
You're fine.
2 things. One, you mentioned before about people buying houses, and I was going to say this before about buying houses with someone who is not your spouse. And you and I had this situation as well. Let me just tell you, and I love, and I love people who are in love. I will tell you that sometimes love ends, and when you are married, there is a court that will handle that. You go to family court, you get a divorce, you get a separation, that judge will decide who gets the house, who pays the mortgage, whatever. There is no such thing for people who have the house when there's no family relationship, your boyfriend, girlfriend, even if you've been in a long-term relationship, the court is not going to take care of that. And I will just tell you, it is just really not a wise idea to purchase a house with someone that you are not married to. But if you do, let me just tell you again, it's better to make these decisions when you're in love, and you think that it's going to last forever and it's never going to end. When you all are getting along and all that kind of stuff, maybe that's the best time to have a lawyer draw up some kind of agreement so that, there is something done. We do closing sometimes, and it's boyfriend and girlfriend, and they're buying a house together, and it may be, he's on the mortgage, but he wants to add her to the title, and she's on house. We usually advise against it, but if they typically want to do it, we also advise that they actually do some kind of contract as to what that means. If the mortgage is in his name and he's legally responsible for the mortgage, what does that mean? Can he force her to sign her interest over if the relationship goes south? So, I mean, those are some things that you have to think about. But I did want to say that. And then in addition to that, when you think about a deed, if you are married, make sure that you are looking at your deed. Most closing attorneys do joint tenants with right to survivorship, which means that house passes automatically to the other person upon death. But if that is not, if you don't know that, pull out your deed and check. That is one of the best things that you need to do, can do to make sure that you are safeguarded. I have a current case right now. Husband and wife, they married 50 something years, but 50 years ago, women weren't on houses, and so the house was only in his name. He didn't have a will, and so she inherits half the house, but his children inherit half the other house. He has children with her, but he also has children with someone else, and so it's just complicated. And so, but had he changed the deed even 2 years ago and added her with right to survivorship, we'd be okay. So I'm just strongly encouraging you, especially because I know older people, if your mom and daddy have their house, just ask them to pull out the deed so you can see it. And if it's not with right to survivorship, a quick deed change, a quick claim deed is going to cost you $250. I mean, it's not going to cost you much, but it will save your mom, your dad tons of money if something were to happen to one of them.
Somebody put on that. You can't see on the Instagram side, but somebody put on there, amen, to what you were saying. And that's something that people don't think about that, because like you said, in the home for the last 50 years, nobody's even thinking about asking the deed. And guys, I'm going to tell you, everything is cordial until there's money and property involved. I'm just being honest with you. Even when it comes to life insurance policies, and when it comes to even with purchasing a home, everybody is cordial until there's money involved. And so I never even thought about what you just stated. They were married for 50 plus years, but they have children from prior to getting married. So now there's no will. This child comes, is like, hey, and they have the right. Per the law, they have the right, whether you know them, whether they was at the cookout last year or not, or at the funeral or not, they have the right now to come in and ask for and make decisions, not just ask, but also be active in the decisions of what happens to that property. Meaning that if you want the youngest brother to stay in there, they have to agree to it. If you're going to rent it out, they deserve a portion of the rent. You don't have everybody jumping up there raising their hands to pay the expenses, but you do have them having their hand out to get a portion of whatever proceeds are coming in.
Absolutely.
Oh my goodness, information. I want to touch on and just ask this one. Oh, somebody asked a question. Somebody asked, can you name that? I'm assuming what you say. And hey, if I'm not asking your question right, just let me know. But they want to know that can everyone name a specific child to everything? Like, can they just say, hey, I have children. One of my children's name is Jaden. He's the oldest. Can you state, hey, I want all of my assets to go to Jaden McFadden?
Mm-hmm. Yeah, absolutely. Absolutely. And you can be as detailed or as vague as you want in the will, but yes. So if you've got several things, like if you say, okay, like I get parents and they say, I want to leave the house to all 5 kids, and I tell them it's not a great idea, and they start thinking about it, and they're like, okay, well, I got to leave everybody something. So, okay, I'm going to leave the house to this child. I'm going to leave my car to this child. I'm going to leave my jewelry to this child. So you can do that. I mean, you can get as detailed as you want, but yes, you can name to every specific child. And then if this is what they're asking, yes, again, you can name to all 5, but practically speaking, that's just usually not the best thing to do.
Okay. All right. And I know we're wrapping it up here because I want to make sure I get, guys, if you have any other questions, put in the chat, but I want to make sure I asked you in regards to, are there any with them getting ahead. Oh, okay. If there's something, and then there's a second part to that question. If you do not want a specific child to leave something to, and making sure. So I'm assuming that kind of handles, like, if you have it to whereas you want X, Y, and Z child to be able to get this and not have this child get that. When they list that out for you in the will, that's exactly how it can go. And can it be contested? I hope I got her.
So a lot of wills have no contest clauses. And so it depends on the will and what what they've put in there, how tightly worded it is. They can have a no contest clause. And so if you feel like, hey, the will, my dad wouldn't have left me out, so I'm going to contest it, and dad has a no contest clause in there, potentially you contesting it, unless you have something legitimate to show. Unless you have something legitimate to show, you contesting the will might completely leave you out. So you want to be thoughtful with your contest. Like, I have a will contest we just did. They knew, they felt like the father was not, they felt that the father would never have done what he did in the will. And so then once we looked into it, the will was done. He was under the influence of drugs at the time. He was medication and stuff. We questioned, some of the things that happened around it, and we challenged it. And once we challenged it, the person who presented the will ended up withdrawing the will because they couldn't stand behind it.
Yeah, and another thing that I'm seeing too when I see certain things, guys, is you also, and Tameika, you can correct me if I'm wrong on this, you can also designate the keep in mind your children get older too, and when you talk about children, unfortunately, you may have one child specified to do X, Y, and Z, and unfortunately, they may pass. So it might be best if you're going to have a personal representative that you have it in line. Now, it also, okay, if the oldest child is here, okay, and should something happen to the oldest child, then the next child is in line to be the person represented. Those are things you have to think about. And I know it's so hard for us to talk about death, but the reality of it is, guys, these things happen, and you want to be prepared. You want to be on the, okay, I'm prepared if this happened. It's not necessarily it's really not an if, it's a when, honestly. And so you just want to make sure that you're prepared. And this is how you do that by speaking with Ms. Tameika. I have just one more question, and I don't know if I see any other questions. In regards, are there any type of tax implications when you're transferring real estate through probate, through estate planning? Are there ways that you could be able to get? Because I know here in South Carolina, we have property taxes. And a lot of people out in other states, they don't really have it, but here we do. And you already touched on, if you don't have it, if nobody's occupying the property, how it can be able to, those property taxes go up higher to a better rate. Are there any things to be able to save as far as when it comes to the heirs with probate, as far as with having plans to avoid paying tax on certain things, or is it even avoidable, so to speak?
Right. So it's unavoidable to pay property taxes. So you have to pay property taxes. As far as inheritance tax, actually, South Carolina is one of the better states as it relates to inheritance tax. So there really isn't, unless the estate itself is worth, and I cannot remember because I usually don't have these kind of estates, but unless the estate itself is worth like $5 million or something like that, there is no inheritance tax on it. Now, the one thing that people will get is, like, say you inherit. So I remember when my father passed away, he had lots of property. I got some, my brother got some, my mom got some. And so the next year, of course, the value of the property that I inherited was reported on my taxes. And so that did increase kind of what what I had. And then, of course, I get rental income. And so those are some things I think you have to think about. But what I tell people, you need to talk to whoever your financial advisor, your tax attorney, your tax planner, to talk about how do you mitigate those things. And so sometimes sometimes people do, put them in the trust so that it's not personally in their name or that kind of thing. If it's enough of a financial hit to you, there are things that you can do to avoid it, but I'm not a tax attorney. So although I can do what you asked me to do, whether it's put in a trust or put in an LLC or something like that, you need to ask your tax advisor, because it depends also what your assets are and what your tax bracket is.
Okay. Awesome. Well, Tameika, I know we're kind of coming up on the time, and I didn't want to hold you too long, and I'm so grateful for your time and expertise. Was there anything else that you would like to share with everyone, or anything else that you would like to share with the community? I have your information down here, guys. Please, I hope you've been taking snapshots of this. But anything else that you want to leave with us for this evening?
Nothing else for me. I thank you so much for your time. I know it's a lot of information. And so what I tell people, I talked a lot about different scenarios, but the best thing to do is, if you have questions, happy, for you to give me a call, set up a consultation. We can kind of talk about your specific situation and design an estate plan that's very specific to you and your needs.
Yes, and we had someone who put a comment saying this has been very informative. Thank you. Guys, I just want to thank you all so much for coming on. It was very important for me to have Tameika on, like I stated at the beginning, because we work on these files. These are things we're talking about, are things that we've seen that have happened. And again, it's all about being prepared, because we don't want it to where your property gets taken by the state. We don't want property being taken away by heirs that you didn't expect. And so it's just all about just being prepared. And that's what this is all about. Tameika, I just want to thank you so much for your time today. I'm actually very excited, and I've been excited the whole time ever since you agreed to do this, because it was just great information. And I just thank you so much for the service that not only that you have done for your clients, but also for the community. And it shows right here of how much, guys, if you can't see it, go back and replay this to see how much not only that she's knowledgeable, but she cares about her clients and getting things done. And that's why I just knew it was important to have her on here. For all of you all, if you do not have a will, even if you have a will and you just want to make sure, because again, I know there's all types of things online, from LegalZoom to what's the other thing that you get, the legal chats. I know there's so many things out there, and we're all in this do-it-yourself society. But guys, when it comes to this is important. Make sure that you reach out. I have her contact information that is to her office, as well as her website, for you all to reach out to Tameika in regards to setting up your appointment. She is here in South Carolina, but Tameika, correct me if I'm wrong, you do travel across the state, and they can be able to come to you too. So if you're not in Columbia, South Carolina, you could be able to set up an appointment. And probably some of the things, I don't know if she does virtually, but hey, reach out to her and get it set up. The main thing is we want to see you on this front end getting it squared away versus us having to deal with it on the back end. Okay. All right. All right. As always, I thank you so much for joining us for our Tuesday tune-ins. They are every Tuesday, guys, at 7 p.m. If Miss Tameika is available, hey, I would love to do a segment of who owns your house. You kind of touched into it today, but there's just anything else that you would like to share with the community, please let us know. I'll be more than happy to have you come back, because this is every Tuesday. Let me know what you want to talk about. Guys, if you're interested in buying and selling, if you're in this type of situation and you do have an estate property, you have two experts right here in front of you. You have myself in regards to, you can reach out to dealswithangie.com, and you can also contact me on my cell phone. And then you also have Miss Tameika to schedule your appointment. I say do it now. Don't wait. Okay? Do not wait. Schedule it today. Send us an email. You can go ahead and reach out to us. Now, she won't be able to reach out to you tonight, and I won't either, but I promise you we'll reach out to you all to get this squared away. Miss Tameika, thank you as always. Always a pleasure. I wish you the best in regards to everything that's going on, to the lovely senator. And thank you again for everyone for joining us. Have a blessed one.